and welcome to Let's Talk HR with Dr. Deneen, the talk show that spotlights HR professionals and talks about all things HR. Today, we're talking about the buzz around the halted overtime law, also known as the new exemption rule under the Fair Labor Standards Act, originally set to take effect January 2025. The U.S. District Court in Texas has stopped it in its tracks. So what does that mean for employers? So does that impact your compliance strategies? So what's your next move? Joining me today is Jeff Weintraub, partner, Phillips, LLC, and he's gonna help us navigate the details of the overtime exemption rule changes and provide clarity and give us some actionable insights. Plus, that's not all. Attorney Weintraub will also share with us the recent groundbreaking decision by the National Labor Relations Board. So sit tight. We're gonna talk about it as we talk about HR. Jeff Weintraub, attorney, partner, Phillips, thank you so much for coming.
You're welcome, but I don't know why you invited me. I have no clue about any of this stuff.
Oh boy, we're in trouble, aren't we? So glad that you came in today. We can talk about that. So let me give a little context about it though. Last month, one of the attorneys, one of your up and coming emerging leader attorneys, Malik Luckett, came and he talked to us and he provided all of the insights regarding the overtime exemption rule and how it works. He did an awesome job. I mean, the show took off. The episodes were outstanding. And he told us all about that. So, but out of the blue, here it is. The overtime rule salary increases are now halted. Yeah. So what led to the federal government making this decision to block those decisions or to block those increases?
Well, you'd have to ask the district court judge in the Eastern District of Texas. I can't recall his name, but he's the one that halted the minimum thresholds rule that was set back in April of this year.
Yes.
And he halted it for Texas state employees.
Okay.
But he wanted to take time to consider whether there would be more, nationwide. And sure enough, he's now decided, a couple of weeks after Malik did his discussion of the new rules, they got wiped out, they got blown away.
Wow.
And so the judge said, basically the levels are too high, and they're so high, you're like invalidating the other part of the overtime exemption rule, which is the primary duties test.
Okay, yeah.
You have to have certain duties to be an exempt supervisor or administrator.
Yes.
And the judge says that wipes all that out when you set the level this high. And the level was, it was pretty high. The one January 1 coming in, 58,000 and change. That's really a very high level for requiring, like small employers to, if they're gonna, what do you do if you're a small employer? Can you jump from 35,000 where you were at and then suddenly go to 58,000 plus?
Yeah, that's a lot. That's a lot.
What about the nonprofits out there that, they don't have a lot of money, a lot of funding and stuff? Can they pay 58,000? A lot of companies have been worried about this.
Wow. Yeah, so there was probably some anxiety around it in some cases. Yeah,
huge.
So how does this halted rule affect employers and employees who've already adjusted their salaries, right, and classifications to take part of this? So how does it affect that?
Badly.
Oh my goodness.
Can you imagine, Dr. Deneen, a company that has been complying with the law, and they went from 35,000 to back in July 1 to, what was it, 43,000 and change?
Yeah.
And then maybe announced to their supervisors, we're going to 58,000 plus January 1 under the new rule. And now the new rule is gone, at least at this point. And what do they tell the supervisor? Are they going to reduce the $43,000 they started getting paid in July 1, reduce it back to $35,000, which is now basically the rule?
Wow.
Are they going to say, and by the way, not only are we reducing you, but we're not going to pay that $58,000 we told you were going to get next year?
Wow.
Isn't that a bit of a morale problem, you think?
It's gonna impact workplace culture for years to come.
Oh my gosh.
Yeah.
I guess there will be employers that are going to reduce the $43,000 they're now paying to their exempt supervisors down to the $35,000, and who are not going to pay the $58,000. But I just can't imagine it's going to be such a morale buster.
Yes. Yeah.
It's, there are other things I suppose employers can do. The employer could keep paying the $50,000 or go to the $58,000 like it said it was going to do, and just work the supervisor more hours.
Well, that's one way of looking at it. I'm not sure. But I mean, with that exemption rule, it would allow employers to work a little bit long, employees to work a little bit longer.
They probably wouldn't phrase it that way. They'd probably say, by the way, Bill, you're going to be wearing an additional hat. In 2025 when you start making this $58,000. So on top of your other duties, you got a new hat you're going to be wearing. So, I mean, I guess some employers will do that, but then some employers are just going to, especially the smaller employers, probably are going to go back to the $35,000.
Yeah.
And that, I think, that's a tough road to hoe. It's
going to be. And, when the mandate came out, the HR professionals, we raised our eyebrows anyway, because we were looking at some of those same circumstances. How in the world are the employees going to be able to afford it? But it was a mandate, and people were making it happen. And, just a month away. And I know that a lot of employers are going to try to continue to do that for the sake of morale, for the sake of the employee, still continue to move on with the $58,000. Hopefully everybody will understand it. Maybe, some other resources can come from another way to cover that. But some of my friends are saying that they are still going to continue to do it.
I think a lot of the larger employers are going to continue with the $58,000 in January. Some employers may have already even laid off supervisors.
Wow.
In anticipation of paying the $58,000 when they know they couldn't afford it, like you were talking about. And that is tough. I recall that the Secretary of Labor during the Obama administration was asked about that phenomenon that employers might have to actually lay off supervisors in order to meet the higher threshold that they went to initially during the Obama administration. And he actually went on TV and said two things. He said, first, I don't believe that any employer is going to lay off supervisors just because the salary threshold is higher. But then he said the second thing. The second thing was, but if they do, then those laid off supervisors will have the greatest gift of all, leisure time.
Oh, wow. I do remember that. I do remember that.
It was an unfortunate comment.
Yeah, unfortunate. But hopefully the employers will stay in the same vein and just go ahead and do it. Because I know for sure from a fact when it was told in my organization that we were going to do that, people were just, you saw happy faces. You saw, this is a great thing. We saw that. And then being in the organization that we do not want to roll back. We're just not. We're not going to do it. Yeah. Well, so we're going to make some other strategies on how we can keep that going. But let me ask you this. So what are some of the potential next steps for the Department of Labor, and how might the upcoming administration impact the future of overtime regulations?
That's right. There's going to be a new administration.
It's going to be a new administration.
Yeah, apparently so.
Yeah.
Well, the Department of Labor right now is considering appealing the Texas judge's decision.
Okay.
Now, if they appeal it, it would have to go to the Fifth Circuit Court of Appeals,
okay,
which covers Texas. And the Fifth Circuit has had some recent, very controversial but very conservative decisions.
Mm-hmm.
So the DOL is probably thinking that, hey, if we go to the Fifth Circuit on appeal, we might not do too well.
Mm-hmm.
Plus, with the new administration coming in, there's going to be new people in all these government agencies, and my guess would be that the Trump administration probably would withdraw any support for an appeal by the Department of Labor at the Fifth Circuit of the Texas judge's opinion. I don't have any magic insight here, but it simply seems logical that they would withdraw their support for that. So I don't know, it seems to me we're going to be back at 35,000. And again, that was a number, that 35,000 was a number that the Trump administration liked, 8 years ago, 4 years ago. So my guess is that's where we'll end up. It may go up a little bit. Another thing that hasn't been, I haven't seen this discussed, is that the increase in the minimum thresholds, that wasn't the only thing they did. They did like 3 things. 43,000 plus in July,
right.
January 58,000 plus, but they also stuck in their provision for indexing.
Okay, tell us about that.
So indexing was going to be that after January 1 of 2025 and the new 58,000, then every 3 years, they would look at the number again and increase it based on indexing. Could do the, I don't know, consumer price index or something. I'm not really sure what. So it wasn't going to be 58,000 probably more than 3 years anyway.
And it was going to increase.
Oh yeah, absolutely.
So with this new decision, did that debunk the indexing, or is that going to be part of?
I think we're going to have to wait and see what the Trump administration does on indexing. Indexing does kind of make sense. If you go back to the way it was 20 years ago, I don't know if you remember, but the minimum salary threshold at that time was 20-something thousand. I forget exactly what it was, 23,000, 25 something. And that was too low for a minimum threshold for supervisors. So because they didn't have indexing back then, it stayed that way for 20 years. And it should have changed. And that's why there was such a demand during the Obama administration to increase it, because it hadn't changed in so many years.
Yeah.
So change is okay. We're not
okay.
against change. And, I think I always felt that during the Obama administration that 35,000 was actually the right number, the number it should be.
All right.
So eventually there may be indexing to increase that, but hopefully in a reasonable way.
Yeah. So indexing, I guess in the HR world and in the business world, it is the same or similar. It's just looking at the trends and making improvements based on that. And it kind of forces them to look at it every 3 years. It forces them to do it. So I think that's a good practice, even if it's not considered part of the rule.
Yeah. The big problem, though, is that, and I've been saying this my whole practice, that stuff like stuff under the Labor Act, stuff under Fair Labor Standards Act and so forth, changes with every new political administration in Washington, and it does. There are infamous cases that have flip-flopped every 4 years with every change from Democratic to Republican to Democratic. And it's a disservice to employers because there's no predictability on these things.
Yeah.
What do you think is going to happen? There's going to be a lot of changes in the next 4 years. But if there's a more liberal administration 4 years from now, it's all going to flip-flop back again.
Oh, my goodness. You can't win for losing here.
Oh, my gosh. Well, it'll be good. It'll keep your show going because there's lots of stuff to talk about.
Lots of stuff. Hey, we got to come back and talk about what's trending now. Absolutely. So what kind of lessons can HR professionals learn from this back and forth overtime regulations, and how can they best adapt for legal uncertainties in the future?
I think that HR professionals should continue to network with each other at SHRM meetings and so forth so they can cry on each other's shoulders because none of us have any clue what's going to happen next.
Yes, we all cry together.
We can all cry together. Find someone whose shoulders you can cry on so that you don't have to cry at work while you're doing your job.
Yeah.
But I don't know, Dr. D. There's just so much unpredictability here. I think we can safely predict, pretty safely, it's going to be around 35,000.
Okay.
That's probably, that's what it is now.
That's what it is now.
And it'll probably be that in the upcoming administration. And whether or not there'll be indexing, I would think maybe there's a good chance of some type of indexing. So I think employers should budget, and HR folks should budget around the $35,000 figure.
Okay.
For the future.
So there you have it.
And then if it all changes again, 3 months, you can have Malik come back and correct me.
Well, I have one of you back, to talk about what's new now. But that's good, to know that, most likely it's predicted that the 35 is going to be there, and there may be some uncertainties that will come in the future. But at least we know we're pretty safe with thinking as we do our strategies and compliance strateges and budgeting for the next year.
So now you're on the record saying that's pretty safe to go with that.
I said kind of safe. I did say pretty safe.
If it doesn't work out, they can blame both of us. 'Cause we're both saying that.
They go, listen, I'm going to say, call Jeff, don't call me. So now let's flip it a little bit. There is also a new groundbreaking decision from the National Labor Relations Board.
Oh my gosh.
And it's fresh off the press too, a week old, right? So tell us about that.
Well, back in the day, before things started changing so rapidly, when I would go on shows like this or write articles or speak for webinars, they didn't have webinars, but seminars and stuff like that, I would check the status of the laws like a month or so before I was to speak. So in case something had changed. Now I check it the morning of. and Dr. D, this morning.
No.
I checked all my new reporter services, see if anything had changed overnight.
Okay.
Just to make sure. And some things did, but they didn't affect this stuff. So this is another. Every political administration, a lot of these laws change. This is another one.
Okay.
And this is the captive audience rule that we're talking about. Let me explain. Can I explain what the captive audience rule is?
Yes, tell us what the captive audience rule is.
Yeah. Some people refer to this as the 24-hour speech or the 25th hour speech.
Wow.
I'll explain that. But what happens when a union comes in to try to organize a non-union company?
Okay.
The union will make lots of promises. Now, I know this, and people say management lawyers are anti-union. I used to be a member of Teamsters 667. Back in the days when I had a real job in Memphis, before I became a lawyer, I worked at Campbell 66, a defunct company, on the loading dock. I was an unloader, a lumper, and I was a member of Teamsters 667.
Okay.
So I saw it from the inside out and from the outside in. So what happened is unions would tell employees, make lots of promises. We're going to get you better wages, better benefits, seniority is going to be more meaningful, all this different stuff. Why would they do that? Well, because they wanted to gain members. Why would they want to gain members? Because frankly, a union is a business.
Okay.
And you have a business that you work at, and all businesses are pretty much the same. They have to have money coming in. They have to have revenues.
Yes.
To survive. Well, a union to survive and to pay its officials handsome salaries, which most of them do, they have to have revenue, and their revenue is dues. And the dues are paid by the employees for the companies that the union organizes. So that's why the union is out there making promises to the employees.
Okay.
Can the union keep these promises? Infrequently. Has been the overall experience. I sometimes, don't get mad at me, I bumped into a union lawyer friend of mine at the grocery store yesterday, so I don't want her to get mad at me. Sometimes they kept the promises, but most of the time the promises were not kept. There was a way of getting in to the company and getting the employees to vote for a union. So these promises needed to be responded to by the employers.
Okay.
The employers need to be able to say, for example, unions will generally tell employees, don't worry about a strike because we don't strike very much, and if we do, you can't be fired for striking. And that is true. the right to strike is a protected right under the National Labor Relations Act.
Uh-huh.
But what the union will not tell the prospective members, the employees, is that while the union has the right to strike, during a strike, the employer has a right to operate, meaning that the employees, the strikers, can be permanently replaced. As long as they are given a priority recall. If the strike ends and the jobs haven't been filled, they come back. But if the jobs have been filled, generally speaking, they get to, the replacements get to say. So I don't know if you can tell much difference between losing your job or being permanently replaced. There is a little difference, but
there's just a little bit of.
So someone has to tell the employees the other side of the equation.
Yeah.
And that was the employers who would respond to the things the employers were saying in these captive audience meetings. So a captive audience meeting is where the employer would gather all the employees, require them to attend.
Yes, make it a requirement, make it mandatory.
Make it mandatory. They were compelled to attend. And there would be speakers. The employer would address some of these promises that have been made. Said, okay, now you've heard this side of the story. Now we want to give you the full side of the story, because if you're going to vote pretty soon in a secret ballot election to decide whether or not to have a union at our company, you need to have all the facts. When you buy a used car, do you want to know if that car has been in a wreck previously, has been gotten Bondo on it and replaced? Yeah, you want to know everything. You want to kick the tires. You want to find out all the facts, not just from one side.
Yes.
So we're here today in this captive audience meeting to give you all the facts.
Yes.
And the employers were limited. They couldn't do things that were, the employers aren't allowed to make promises. The union can, but the employer can't under the Labor Act.
Okay.
So there were rules regarding these meetings, but the employers had the right to do this, to pay the employees to come and attend these meetings and listen to the free speech of the employer. Well, that was all fine and good.
Yeah.
And then in 2022, the general counsel of the board, Jennifer Abruzzo, issued a memo in which she said, we don't like this captive audience stuff. The employees should not be compelled to come to these meetings and hear the free speech of the employer. Well, here in 2024, a week ago, the board followed up and did exactly what General Counsel Abruzzo wanted.
Wow.
They banned captive audience meetings.
Banded captive audience meetings.
So
with employees.
They said no more. You can't compel the employees to come and listen to your free speech about this.
Wow. So they banned that. So can employees come if they want to?
They can. Employers are now they're going to be allowed to have voluntary meetings.
Okay.
So the employer can now put out an announcement that says to the employees, we're going to have a voluntary meeting. Here's such and such a date, and the following topics will be discussed, among them unionization and so forth. And we invite you to attend. It'll be on working time. You're not required to attend. And there'll be some, the board has said in its decision, which is an Amazon case decision, that there's going to be some limitations on that. The employer has to give good advance notice of the meeting.
Okay.
Has to tell the employees.
Well in advance.
Well in advance. Has to tell the employees what the topics are going to be.
Huh. Okay.
And also has to tell the employees, if you don't want to come, you will not be disciplined. You will not be retaliated against.
Right.
And the employer can't keep a list of attendees. Like you sign when you come in.
So they can keep that? They cannot.
Cannot do that.
Wow.
Because that sends the message, according to the board, that they're going to be disciplined if their name is not on the list.
Wow.
So no retaliation, none of that stuff. And then the employer can have his meeting and respond to the things that are being said by the union out there. So it's tough. So basically what the board said in the Amazon case is, employer, it's okay to engage in persuasion, which is trying to persuade the employees not to vote for a union. But you can't compel employees to come to a meeting and hear persuasion. So you can do it voluntarily. We'll see.
So what can organizations do to still be able to talk to their employees be influential in what, they want to tell their employees. I mean, what are some strategies that employers can do? Can they make it, we're going to have bi-monthly, quarterly meetings?
Sure.
Yeah.
Voluntary.
Voluntary, yeah.
You don't have to attend. You
Yeah.
won't be disciplined for not
Yeah.
attending. But yeah, you can have these meetings. And by the way, that you mentioned quarterly and so forth. The reason they used to call it a 24-hour speech or a 25th hour speech is that the board's rule, employers could have captive audience meeting, but you couldn't do it in the 24 hours before the election, before the vote.
Oh, I see.
So that's why they call it 20.
Yeah.
So
Yeah.
the employer can schedule these discussions. Will the board say that, Mr. Employer, if you haven't been doing these quarterly meetings all along, then you can't do them now? And I don't know. We'll have to wait and see it. Some attorneys are predicting that the board may go in that direction. Say, if you haven't been doing the meetings already, you can't start doing them now.
You can't start doing them
because of
now.
the election.
Oh,
but
my
I don't know. We're going to have to wait and see if they do that. Employers are going to need to prepare carefully because they have to stick with the facts.
Okay.
If they go beyond the facts, the union doesn't have to stick to the facts. They go and make wild promises. But the employer does, and the present board is going to cause trouble for employers that make predictions not based on facts. There's a recent board case, another case, it was just a couple months ago, where an employer had predicted that if the union comes in, there'll be less direct communication from the employees with management. You won't be able to talk to your managers as much. And the board said, no, that's not necessarily true. So employers can't make these kinds of predictions.
Wow.
So it's very, very limited. That's why supervisors need to be trained on this stuff. Usually training is the TIPS formula. Employers can't threaten, that's the T.
Okay.
The employers can't interrogate employees as to how they're going to vote.
Okay.
I'll skip to the S. They can't spy or surveil on employees to see who's attending the union meeting and so forth. And the P is promise. Employer can't make promises to the employees to get the employees to vote for them. And it's always been weird to me because the unions can make promises lawfully.
But the employers can't.
Employer can't. The board says it's because only the employer can make effective promises, which is maybe true. But when union representatives tell employees, we're going to get you this and that, it's an effective promise. Some employees are going to believe that the union rep can get them this stuff. So to me, that's always been an effective promise. And I've never liked that rule that the unions can promise and the employers
cannot. Wow. This has been an episode full of information. I mean, I'm still spiraling from it. What we can and cannot do. Wow, we have learned so much about the halted new overtime exemption rule and gained insights and strategies on how to navigate through the details of the rule changes. Plus, we've learned about the recent groundbreaking new decision by the National Labor Relations Board. Fantastic. And I want to thank Jeff Weintraub for all of his expertise in this. Call him if you need him. As HR professionals, we oftentimes, and we must stay abreast of new laws, trending strategies, and information that promotes a strong and effective workplace culture. HR professionals can be the resource to help educate, guide, and be the trusted advisor to obtain workplace success. Be sure to watch a new episode of Let's Talk HR with Dr. Deneen, the first of every month on the YouTube channel of the same name, and on Comcast Xfinity Channel 17 Monday nights from 8 p.m. to 8:30 p.m. Please note, you can watch Let's Talk HR with Dr. Deneen and prior episodes at any time. Go to the YouTube channel and type in the talk show title. Be sure to subscribe, no fee, and click on the notification bell. This is HR TV. I'm Dr. Deneen, and I want to talk HR with you. HR forever. See you next time.